right. Let's see that. Bam, I like those levels. All right, Jello again. This is Ben Hitchcock Cross talking to you today. Boy, are my arms tired. Well, almost 300 trees in the ground, like 275, 280 somewhere in there. Some are still left to be potted. It's true, but we got all the ones in the ground, so that's a pretty big achievement. A lot of oaks this year. Quercus are tough ones. They got this big taproot, and you got to get it. You got to get it down in there protected. I used an auger, battery operated auger for the first time. I've used a huge old gas one on a tripod before. It was pretty nice. Let's see how. My brother, who's a dirt scientist, is probably aghast at the churning of all of the little flora and fauna in the soil there. But we sure pulverized it. Hopefully it's a nice little bed for that plant, and we'll see how that goes, in like 3 years or so. But pretty cool. I only probably have 5 or 6 oaks that I've planted that are still around. Man, you think they're safe, and then bam, they get it going. All right, spring is sprung here. We got the green grass, and we're going to go from there. As always, we sort of march forward before we can go backwards, but this is still the bridge of the Teresa Folaran hearing cancellation. So let's get a little bit more of that before you, so you can kind of figure out what's going on here. All right, I'm going to try to stay off the document screen, I think, just for scrolling. If you want to see it, I guess we can do that, but it's going to be my preference here to just sort of read off screen. I hope that works out for everybody. All right, so as you may or may not know, Deborah Keither, Dr. Deborah Keither to you, has a federal lawsuit out. And that case, as you may not recall, started in the Equal Rights Division with Stephanie Brown. And by hook or by crook, it progressed near to hearing, but then Stephanie Brown postponed the hearing sort of indefinitely again, if that rings any bells, after refusing to rule on any of our motions, but immediately ruling on all of theirs, including that Debbie Keither had to sit for a deposition that they never set up or noticed or, anything. The usual one rule for them, another rule for us, as we've come to expect at the MPS ERD. Let's not recall how that is Dr. Keither's interaction with the ERD started with Matt White and having her case unilaterally postponed by some months because of it was the, quote, MPS media case. Let's not forget that's the Dr. Debbie Keither that the MPS ERD high officials, the division administrator, for example, sought legal advice and refused to give public records to Dr. Keither on the grounds that it was opposed to her legally. Which is strange for somebody who, was setting themselves up as a judicial, quasi-judicial office, and where people can come and file complaints about workplace discrimination. Strange behavior that they would see a complainant who made public records to them as legally opposed to them, but that's what they said. So let's not forget about all that. Let's not forget about the hearings that Stephanie Brown canceled rather than have Dr. Keither attend, and why also not forget that in large part Stephanie Brown is why we have put up so many of these videos up here on the ERD and what happened there. And I mean, it's just sort of hard to imagine. We're just barely starting over again at the federal court here after what happened at the Equal Rights Division. And boy, does it feel like it's all happening all over again here with Folaran. So, and that's also the same Stephanie Brown who has yet to make a decision in Jose Garcia Joven's case that was heard more than a year and 13 months ago. It's kind of surprising here that she would be assigned to this case now. Well, there's a little bit of history that we have to go back because she's now, I think, the fourth ALJ on the case here. And there's some things that I'm just not happy about, and we're going to have to get it out there on the record because it is all public record. So what the heck? So now, at some point after Dr. Keither filed her amended complaint against Milwaukee Public Schools and included Calvin Furman, and basically what happened was the judge dismissed out some of Debbie's claims against specific people, saying that she wasn't specific enough in her complaint. And it basically goes like this. If you want to allege that let's just say a school board member, as opposed to the board itself, okay? The school board violates your constitutional rights by hiring somebody who they don't, is completely unqualified, okay? That's against the school board. It's not against the school itself. The school board can be deliberately indifferent, okay? A school board member, for example, can be personally liable for violating your constitutional rights in and of themselves, personally their own self on the hook, if, for example, they're acting to interfere with your First Amendment rights, or otherwise they're acting to interfere with your constitutional rights, okay? There's a bunch of legal doctrines that make that the case, but we're just going to lay that out there. To plead that, you have to say, board member so-and-so violated my whatever rights by doing such and such, okay? And the judge's decision was that the complaint was insufficiently precise with regard to specific people other than O'Halloran. So there was an allegation in there that O'Halloran had done specific violation of her constitutional rights and not others. So the judge gave Dr. Keither a chance to amend the complaint, as they do, and here we are on her second complaint, and she is a part of this is why I'm explaining, she's naming names and not just being sort of general here, including Calvin Furman. Calvin Furman is an administrative law judge with the state of Wisconsin's Equal Rights Division now. He took over for Alice DeLau, as I believe we've mentioned before. So what happened was that when you added the new names to the complaint, the law firm Von Briesen, which remember is representing Milwaukee Public, the board, the board of Milwaukee school directors, there we go, is representing them against Dr. Keither and others, suing them in federal court, Beverly Williams and so forth. They're also investigating Teresa Folleron's complaints about the MPSU fraud. And they're also representing against Teresa Folleron in the Equal Rights Division, for which Calvin Furman is also an administrative law judge, or hearing examiner, as they're actually called. So there's some issue there. Now, as we've noted, we've raised this issue about ALJ Furman since June of 2023, and it's only now in April, I think, of 12th of 2024 that the judge did something about it. So again, that's 10 months by my count, not a mass surgeon. Okay. Now, there was some issue getting from Chris Reardon, did he actually represent Calvin Furman? And this part of why it's interesting is because we wanted to be clear about it, because he signed his name to a document in federal court saying that he was answering on behalf of Calvin Furman. It's also true that he's representing Jackie Mann on the one hand, and Jackie Mann is also suing the school district on the other hand. So there's a bit of going back and forth there. So, but finally, and on that subject, on the 18th of April, a little more than 10 days ago, I get the following communication from Chris Reardon at Von Briesen. Ben, the firm of Von Briesen and Roper SC is representing Mr. Furman in the Keither lawsuit. Chris. Okay. Pretty simple. But it raised a few issues. I'm going to read some of them that I raised because I think maybe I made a mistake here, but let's see, this is 9:44 a.m. I get this, and at 10:05, it's my suggestion to everybody here that you take a little bit more time than 20 minutes as a general rule to write out these issues, as monumental as they are. So this was copied to the judge in the case, Peter Reinhardt, Chris Reardon, Ramona Natera, that's the division administrator, Calvin Furman, as the ALJ, Nola Hitchcock Cross, Maria Selsor, that's the ALJ and bureau director, regarding, this is on depositions, but this is in response to an old email. This is Judge Reinhardt, Milwaukee Public Schools attorney. Chris Reardon now represents your colleague with whom you consulted on the follow-on case, Calvin Furman, with regard to Dr. Keither's lawsuit against Furman for violations of her federal rights while Furman was employed by the respondent MPS and Milwaukee Public Schools. Mr. Reardon has filed an answer on behalf of Examiner Furman. As you know, Calvin Furman is your colleague, and that you disclosed that you have consulted with your colleague on the follow-on case, but refused to answer whether you confirmed with Examiner Furman. I don't know if we put that tape up out there or not. I don't know. As you know, we intend to call Examiner Furman as a witness in this case. And I want to be clear, this is, as you know, because we've said it several times. That intention was clear to this tribunal and Mr. Reardon prior to Mr. Reardon appearing on behalf of Examiner Furman. We also note that this will put Mr. Reardon in the position of adversely examining his own client, because again, we intend to bring Mr. Furman to give evidence on behalf of us favorably, so that means that Mr. Reardon is going to then cross-examine him. That's how that works. That you could see how that would be problematic for Mr. Reardon, but we'll see what happens. We object to Mr. Reardon's appearance in this case for two reasons. There's a conflict in actual appearance of bias for opposing counsel to represent your colleague whom you may have consulted with on this case. The appearance of bias is too great. We also object to Mr. Reardon's conflict in adversely examining Mr. Furman to the prejudice of my client. How is this tribunal to know who Mr. Reardon is advocating, his client, MPS, or his client, Furman? All right? We raised those issues. Okay, we got a response from Peter Reinhardt saying that he will respond to these issues by the 22nd. Okay? On the 22nd at 4:49 p.m., that's after working hours for state employees, we get this email from Peter Reinhardt. And I keep saying it's the 5th, but I want to be clear, yeah, it's got to be the 6th. All right, so I'm going to say that 4/22 is the end of that day. Okay, so we're really talking 4/23 there. That's less than 2 weeks before the hearing. Any way you look at it, that's less than 2 weeks before It says, recusal order, attachment, signed. Attached is a recusal order in the above referenced case. Please carefully review paragraph 2 of the order, which addresses the hearing being canceled, as well as all other deadlines. ALJ Reinhardt. Okay. Should we read it? Let's read it. Hold on. Why, hello there. All right, let's see what we got. Every time with this one. All right. See the case, Milwaukee Board of School Directors, order on recusal. On April 18th, the complainant's attorney sent this administrative law judge, or hearing examiner, an email informing him that the complainant intends to call administrative law judge Calvin Furman. Yeah, no, we're good. Excuse me. Yeah, I'm sticking with June. I'm sticking with October. I believe it was November, December, January, and February. So, I mean, I guess you can say that it's just the informing part. It's true that I told him that, but I don't know inform here. I guess we can go look that up. Why not? Question, I guess, is can you re-inform somebody? Inform. To give facts or information. Okay, so to inform. Essential, yeah. Well, especially in an official way, that may be part of the definition that I'm quibbling with. It's true that I sent him an email saying that I intend to call them there. It's also true that I tell them that I intended to do that in June. So I guess we'll just leave it at that, at least. And we have it recorded, among other things. But okay. As a witness in her case, the email also raised the issue of actual or potential bias by this ALJ relating to ALJ Furman's hearing testimony. Now, again, I guess it's true that it did say that. It also raised issues about Christopher Reardon as well. So maybe, I mean, possibly that's... You've got the full thing. We'll leave it at that. I'm sorry here. I hate to have somebody else recapitulate my work. Maybe that's it. I'll take you to move on. Discussion. The disqualification of a recusal of an ALJ is governed by the code DWD 218. Pursuant to the code 218.16, upon the administrative law judge's motion or upon the timely and sufficient affidavit filed by any party, the administrative law judge shall determine whether to disqualify himself or herself because of personal bias or other reason. In the instant case, neither party has filed an affidavit requesting recusal. However, for the reason stated herein, the ALJ by his own motion is recusing himself from this case. Now, what that meant was that it's true, and you have to, in order to trigger the shall there, a party must file an affidavit. No question about it. There may be other implications, like, for example, the attorney ethics rules that once you lay things out for them may trigger their need to disqualify themselves. But it's true that according to that rule, that it's not until an affidavit happens. It seems like the same sort of thing's going on there to me. There's one thing is true, but the essential essence of what's going on, the essence, the main operative fact here, which is that once you're aware of the fact that there's a conflict of interest, an attorney is required to divulge that and to possibly take other action. Okay. However, for the reason stated herein, the ALJ is doing it himself. An administrative hearing examiner should recuse himself if he determines that he cannot be impartial in a matter. He should also recuse himself even in cases in which she subjectively believes that she can judge a matter impartially, where her impartiality could reasonably be questioned by others because of an appearance of bias on his part. See, this is fascinating here because almost always you get the case that says an ALJ is presumed to be honest and acting without bias. But you don't get, this is the actual straight up law, and it's a law relating to the WERC is pretty much, it's like the ERD for state employees. Yeah, but it's pretty binding here. And those are two other criminal cases which I have cited. Well, that looks a little suspiciously familiar. Like something I wrote. But hey, what the heck? All right. Here the complainant has stated, or maybe just quoted, an intention to call Examiner Furman as a witness in her case. The undersigned, and has done so since June of last year. I just don't see how you can leave that out. The undersigned examiner interacts regularly with Examiner Furman in the course of his duties and views, I would assume, Examiner Furman as a trustworthy and honest colleague. This ALJ believes that he would be inclined to personal bias and that he would find ALJ Furman's testimony to be credible and give it great weight. Likewise, even if this ALJ did not find himself to be personally biased in favor of ALJ Furman's credibility, the appearance of bias would be too great to overcome given the working relationship and the undersigned ALJ's views of ALJ's Furman's character and honesty. Likewise, if the respondent were to file a motion requesting that ALJ Furman's testimony be excluded from the hearing, this ALJ would be in a difficult position of ruling on whether a colleague should be allowed to testify. Again, regardless of this ALJ's belief that he could be unbiased in such a decision, the appearance of bias is too great. I mean, I guess I wonder if they need to go say trustworthy and honest colleague. I see that there, and there may be some finding that's required them to say on his character and honesty, those being, the things that a hearing examiner is supposed to look into a witness. And obviously they can't go and say that they think that he's untrustworthy or dishonest, even if they did or did not have that opinion. Or, I mean, it's just not in the cards, as they say. No, I mean, nobody would say that. Okay, so I feel, as an explanation to you all, that I think that the statement the ALJ believes that he would be inclined to personal bias and that he would find ALJ Furman's testimony to be credible and give it great weight is like straight out of the book on bias. It's because of the language that seems to be from the 70s or 80s, and certainly quoting a language from another era. That I think there, and I did smirk at the camera and so forth, but I think is the main thing that I'm trying to bring out here. What do we know? We normally call those magic words, right? There was a case before that said, this is the magic formula. We're going to copy the magic formula just the same way as the Day of the Dead or the Book of the Dead from Egypt is going to explain to you the magic incantations necessary to get past, set or what, into the other side. Okay? Same kind of concept. Likewise, if the respondent were to file a motion requesting that ALJ Furman's testimony be excluded from the hearing, this ALJ would be in a difficult position on ruling on whether a colleague should be allowed to testify. Again, regardless of this ALJ's belief that he could be unbiased in such a decision, the appearance of bias is too great. Accordingly, this ALJ believes disqualification is appropriate under Wisconsin Admin Code DWD 21816. I think we raised this issue 10 months earlier. I think the Teresa Falderon has suffered great prejudice in that this order, which should have happened, did not happen much earlier. And now I think we're going to get into what the ERD is in a bind here. But we'll just read this finally out, and then we'll take a brief pause here. All right. Accordingly, disqualification is appropriate. The ALJ disqualifies himself from this case because of the potential for bias or the appearance of bias in deciding whether Calvin Furman should be allowed to testify, and if so, in evaluating the credibility of Calvin Furman's hearing testimony and the weight to give his testimony. The scheduled hearing dates in this case are canceled, as are all pending deadlines, dated at Milwaukee, Wisconsin, April 22nd, 2024. Peter M. Reinhardt. We don't actually know that it's dated at Milwaukee. It could be. We just don't know where he lives, because it's quite clear that the ALJs really are remote workers, which more power to them. It's just that sometimes they have to come in contact with the public. All right. So that is the update on that there. You can see, I think, that there may be a bind, that I guess they're finally realizing the problem that has, we've been explaining to them for at least 10 months now. So I guess that's one thing that's positive. But on the other hand, where the heck does this leave the worker? So that's where we're at. Sorry. We were overcome by the gravity of the situation. Thank goodness for sunlight, dirt, and trees, if you know what I mean. Stick with us, we'll keep you informed.